Hi, it's me again, Kevin Sales, your title rep. I solve real estate problems before they happen. I want to answer a question today that a lot of people ask, whether it comes to probate real estate, regular real estate, or anything. How much does it cost? Don't we all ask that before we buy something? Of course we do. And a personal representative, that's the heir to an estate, is going to be asking the same question. How much is it going to cost to do a probate? I often run across clients that are waiting to list a probate property or waiting to get a property going and get the probate process started, but they can't because of a mythical barrier or the barrier in the mind of the PR as to the cost of the probate. So I said, let's shatter those barriers and let's talk about it today. How much does probate cost? So first of all, there's typically going to be filing fees. You're talking about probably around $400 to file the probate petition, another $400 or so to file the petition for final disbursement. You're going to have some publication fees, which probably are not going to be very high. You may have to pay a court referee to do an appraisal of the property or of an asset, and they typically charge about 1% of the value of that asset for that. So a $300,000 property being appraised by the probate referee is going to cost about $300 for that appraisal. Those are rough figures. Additionally, you may have some miscellaneous fees, fees for certified copies and things like that, but those are some of the general costs. In addition to that, of course, you have the larger expenses, which are the cost for the probate attorney. And the probate code section 10810, sets the maximum that a probate attorney can charge. It also sets the maximum that a personal representative can charge. Again, the personal representative is either the executor or the administrator of the estate. So let me talk about those maximums. Basically, it's 4% of the first $100,000 of the estate, 3% of the next $100,000 of the estate, 2% of the next $800,000 of the estate. Now the next $9 million, you pay 1% of it, so 1% of the next $9 million, and 0.5% of the next $15 million of the estate. If the estate happens to be more than $25 million, then the court would figure out what the cost should be on that estate. And these costs, the 4% of $100,000, that's $100,000 of the estate, not just equity in real estate or something like that. So for instance, if you have a property that's worth $500,000, but they owe $400,000, the value of that asset is $500,000. So you would be paying the percentage on that rather than on just the $100,000 of equity. Hope that makes sense. Now, the thing that people don't always realize is that the personal representative, the executor or the administrator, as well as the attorney, can charge those fees. So those you could have double. Instead of 4% of the first $100,000, could be 4% to the attorney and 4% to the personal representative. These fees are only allowed to be charged once the court or the judge signs the final order for distribution. So legally, technically, they can't really charge those until the court orders it. It's not really legal for them to accept those fees until the court orders that. So it's something important to know. One great way you can establish rapport, and one thing that I've seen done many times when it comes to the closing of a transaction, is having a demand in escrow for some of these fees. So oftentimes we'll see a demand from the attorney saying, hey, $8,000 out of this estate or out of this sale needs to be paid to the attorney or something like that. And when that money is collectible, when it's legally allowed for them to collect, and that sort of thing is not our business. If we have a demand in escrow signed by the personal representative, escrow's job is to make sure that demand gets paid. It's a great way you can establish rapport with the attorneys, because I've heard many cases where the attorneys get burned and they don't get paid. Property sells, check goes to the PR, and then when it comes time to pay the attorney, obviously they've spent the money, mysteriously all the money's gone. So it's a good way to create rapport with your attorneys and protect their money, their fees, and therefore, hopefully, get more business from them. As always, consult your legal advisor, consult your tax advisor, because you want to make sure that what you do is right for the particular situation. Okay? It's a very important point. I always advise that you should advise your clients in the same way. Last thing I want to say is, if there's a problem in your business, together we can solve it. Call me if you have any questions. As always, consult your own legal and tax professionals for advice. To reach me, Kevin Sales, your probate specialist, you can email me at probatetitle@gmail.com or call me at 213-364-3810.